Hello and welcome to Hire Results, where business, workforce, and talent intersect. I'm Melody Brakin, CEO of ITI Workforce and your host. On Hire Results, we cover all things HR throughout the life cycle of a worker. In addition to that, we pay attention to you and your career. And today we're doing a little bit of a pivot. Today we're going to talk about the legal side and lawsuits and your rights as a worker. And you guys, you know I have my favorite guest. I have Justin Vaughn, the business owner's attorney. However, today we're going to be talking about you as workers. Now, I want to share with you of EEOC cases. In the last year, I'm going to give you the exact number, we had 84,254. Now, what's interesting is if you look at the last 10 years, and EEOC cases relate to discrimination and a few other things. In the United States, we've had between 82,000 and 100,000 charges each year, just so you know, as far as filing charges. What's interesting is that last year it actually went down over the last several years. However, so how does that relate to our workforce? In the United States today, we have about 161.5 million workers in what is known as our civilian labor force. So these are the individuals that are eligible for work. These are 16 years and up, so that you know. And interestingly enough, not even 1% of the number of workers that we have we had charges. But charges are real, and you do have rights as a worker, and we're going to delve into those today. Let's talk about what are most lawsuits around for employees. Most of them relate to discrimination, harassment, wrongful termination, retaliation, and injury. Listen to me. When does it cross the line between something actually happening and it becoming illegal? And that's what we're going to talk about today. So with that, welcome to the show, Justin.
Thank you, Melody.
It's always fabulous to have you here.
Always great to be here.
Just to jump in a little bit, and even though I always say you're the business owner attorney, tell everybody a little bit about you and what I love in your practice. Besides business law, you do injury law too. So just...
We do. I've been an attorney for 25 years. I have a practice that primarily focuses on business issues. I've done a number of employee issues on both sides, representing both employees at times for claims that they may bring forward. I've worked in conjunction with the EEOC on a number of those claims. I actually am acquainted and friends with a former national counsel for the EEOC. So this is a very comfortable setting for me, and thank you for having me.
Fantastic. All right. Well, I want to jump in. And one of the things that I want to jump in with is let's dig into some of the lawsuits and the perspective from the employee themselves, okay? And I want to take each of the categories that I just listed. Let's start off with discrimination. So as a worker, and as we go through the show today, I'm going to probably throw a couple of scenarios at you as we just have our discussion. But let's dig in. Discrimination can come in any form: age, disability, genetic information. I want you guys all to know from a worker perspective, national origin, race, color, religion, sex. And by the way, when we put that under sex actually means gender, but we also include pregnancy in that. We're somebody in terms of being pregnant. So,
and more recently, including orientation and transgender issues.
That's right. Oh, absolutely. Absolutely. So with regard to that, Justin, share with me what are my rights as a worker when I work for somebody with regard to this. What should I expect? Because here's the other thing. When I think about this, kind of a misunderstanding that we have is we think our employers should treat us fair and nice all the time. Well, guess what? That's not part of the requirements. There's nothing legal out there for anybody at all that says, hey, I'm going to treat you well at work, right?
Particularly not nice.
Nice
is not necessarily the criteria, but the main criteria is, and the question to ask as an employee is, are you in a protected class? And you did a wonderful job of listing those out. The Age Discrimination Employment Act says you're protected if you're over 40 from discriminatory actions. And by discriminatory actions, we're talking about discrimination in hiring, in salaries, in benefits, in workplace conditions, treatment, terminations, retaliations. It covers all of those.
Okay, great.
So discrimination takes the form of making a decision or being treated a certain way because you are in that protected class. So there's age discrimination if you're over 40. There's disability discrimination under the Americans with Disabilities Act, and that was amended in 2011 under the Americans with Disabilities Amendment Act. And for disabilities, the employer is required to make reasonable accommodations. So if you have a disability that is not experienced by a majority of the population, you have some medical condition that creates a need for a reasonable accommodation, you can make the request for that reasonable accommodation, and failure to do so or disparate treatment because of that disability constitutes discrimination.
Okay, so let's jump in, though.
Sure.
I'm sitting in a place, I'm over 40, I'm in my job, I get fired. Do I have a right to a lawsuit? Can I do something about that?
It depends on the reason.
Okay.
If the reason is, and I'll give you a good example.
Great.
Large company fires a substantial number of people. They had 7 senior level executives, large benefits, had accumulated large salaries, all over 40, and they fired them in a sweeping move and brought in brand new college students, minimal benefits, minimal salaries to do the same jobs. Okay, that is a blatant violation of Age Discrimination and Employment Act. It's meant to protect those kind of benefits. And when you do a group firing and everybody's over 40 and has those circumstances and you replace them with everybody under 40, then you start to cross that line. Now, it's up to the employer to come forward and justify that termination decision in a non-discriminatory way. In other words, they have to say, no, it wasn't because somebody was over 40, it was because of X, Y, and Z, and they have to come forward with some type of proof that that termination was appropriate.
So, okay, let's stay within this.
Sure.
What, in terms of rights, what are my rights even at a religious level, let's just say?
Sure. For
me at work every day, if I want to come and I want to share, what if I want to do a Bible group at my break or at lunch and we all get together? Or what if at different times throughout the day I pray at my desk? Do I have the right to do that? Or
well, and again, it's there are employee rights to do certain things, there are employer rights, and there are restrictions on the employer to do certain things. So you're touching upon, we talked about age discrimination, we talked about disability discrimination. Now you're touching upon one of the Title VII categories under the Civil Rights Act of 1965, which protects against discrimination for religion, which is the category that protects against discrimination based on gender or orientation, transgender issues now. It's the protection against discrimination based on nationality or ethnicity.
Okay.
So those are all protected classes.
Right.
One of the more recent examples was somebody who wore I'm gonna
tattoos on their face, or?
The head covering.
In terms of
Muslim
wearing a
groups.
burqa.
Yeah, thank you.
Yeah, you're quite welcome.
And so the Supreme Court considered that, and somebody was being hired for a position at one of the clothing places that sells at the mall, and they have a dress code, and you have to wear their attire.
Can I have a dress code?
And the Supreme Court said you can't discriminate based on that because it is a religiously based belief. You can't refuse to hire somebody when they are expressing a religious belief. So your example of saying a prayer, having a Bible session, you can't interfere with workplace operations, but to the extent you have a religious belief founded on that, and Hobby Lobby is a good example of those types of issues. When those come up, employers have to be very careful because they have to make room for that. They can't discriminate either in hiring, firing, work conditions against a legitimately held religious belief.
But they also have the right to create a fair and balanced work environment. So
Right.
it's how they go about accommodating. So one of the things that you have to look for is you have to look for how they are accommodating. It might be that on your breaks you can do this, and here's a space that you could do it, but in these public settings you cannot. Which I'm going to go to. Let's dig in a little bit with dress codes. What are my rights as a worker with dress codes? And I'm going to jump seriously into this for a second.
Sure.
Can an employer tell me I have to wear a bra to work?
Ooh, great question.
Ooh.
Great question. And the answer is going to potentially be different in different courts. But I think we could take an example from, for example, New York.
Yeah.
Okay. In New York, the decision has come out that says that because men can be topless in a public park, so can women.
Yeah.
Okay. Now I'm taking your bra example one step further.
Oh, totally. And by the way, we've had a little bit of that here in Colorado as well. Even in Boulder, we've had individuals running around. Yeah.
That's right. And that is an issue. So some of those cases have come out now in other courts in other parts of the country. I think it may well end up in a different outcome. So I think in Colorado, an employer is going to have a hard time doing that. Now, the argument that it's disruptive to the workplace. An employer would have a hard
time telling me I have to wear a bra.
Yes.
So exactly, just as far as the comfort for a person, but you can establish a dress code. Like I can say that you have to wear business attire as an employer.
Yes.
So for an employee, I can't show up at work. And I can't have an issue with my employer because I'm wearing a swimsuit to work. And understand that culturally changes over time as well. Yeah, it does.
The argument of, and the answer is yes. You have to wear, if an employer has a dress code that is reasonable and appropriate to that workplace, that's going to be upheld by the courts. But the argument of you have to dress a certain way, you have to present a certain way, and the attempt by employers to say it has to be appropriate for the environment of the business and the comfort of the clientele is going to be a tough issue because those are the same arguments that appeared in the 1960s with regard to ethnicity and nationality to say, oh, no, my employees are going to feel uncomfortable if I hire somebody who is of a different skin color. And my clients or my customers are going to be uncomfortable. Well, over time, that has evolved. And culturally, clearly, that's not the case now. The Civil Rights Act of 1965 set the legal foundation, but culturally, that's just not going to fly. And in terms of attire, I think we're seeing a cultural shift there as well. And I think we're going to continue to see that. Certainly with orientation, with transgender issues, we're seeing a cultural shift. So as that changes, employers need to be very careful of that. You don't want to be the test case employer. And employees need to be cognizant of that is going to be an evolving issue.
By the way, one of the things that Justin has just pointed out that everybody you need to keep in mind is what state are you in? Each state are going to, states' rights. Each states are going to have different leanings. So pay attention to the states that you're in.
And certain employers will fall under the category of federal classifications. So, for example, the Age Discrimination and Employment Act puts you into the EEOC and into potentially federal courts if you have 20 or more employees. The Americans with Disabilities Act, Title VII under the Civil Rights Act, those apply to 15 or more employees. Now, in Colorado, for example, the Colorado anti-discrimination laws and the Colorado Civil Rights Division have authority to enforce any employment issue. So if you have one or more employees, you fall within their jurisdiction. And Colorado's Anti-Discrimination Act, the CADA provisions, basically combine discrimination laws from age discrimination, disability discrimination, and all the Title VII protections in one. So any of those can fall under the protections of the Civil Rights Division in Colorado.
By the way, I love that. That's another thing you got to pay attention to. Is it a state-related issue? Is it a federal-related issue? Or is it both? And make sure that you have an attorney that knows the difference and knows the the laws that apply, because this is the kind of thing that if something happens and it's putting the law behind you, you need an attorney. You're going to have a case, and you're going to have to follow up on it. Well, I'm going to dig into a couple of others. Yeah.
Well, let me add one more thing to that, if I may. Also, if there is a question about whether rights have been violated, and you don't feel like there's a remedy that's been offered by the employer, it is always a good idea to consult with an attorney. But also, you can go directly to the EEOC and ask those questions, and they are there to help you. You can go directly to the Colorado Civil Rights Division and ask those questions, and then decide whether to pursue a formal claim through those. If they decide to run with the claim, then they'll set up mediations, discussions. They'll lodge a formal claim potentially and get a response from the employer. If they decide not to pursue it, they'll give the employee what's called a right to sue letter, which means the employee then has the right to go and pursue a civil lawsuit if they choose to do that.
Fantastic. By the way, excellent information. That was fantastic.
Oh, thank you.
The next one, I'm going to jump. We all talk about harassment. We've covered this. I am not going to cover it from the standard perspective. I'm going to cover it from bullying. In terms of a hostile work environment, what is it? So I'm just going to throw a couple of scenarios at you, because we talk about bullying, and then we also talk about a hostile work environment as far as what constitutes that hostile work environment. So if I start breaking it down with what is hostile, if somebody is raising their voice maybe periodically, or you're in a debate in a meeting, or somebody uses a cuss word, or I have to go into a work environment that has a whole bunch of animals in it. And I don't want to. So what constitutes a hostile work environment?
Animals meaning four-legged or two-legged?
No, okay. Four-legged.
Okay, we're talking about employer.
Okay. So, what is that? Where's the line, and where do I have rights as a worker?
Sure, and it comes back to those same protected classes. The question is, are you being treated the way you're treated, or is the environment hostile because of the implication of one of those protected classes? And I'll give you an example.
Yeah.
There was a case with an employer that everybody agreed was just an ass. Okay, was one of those two-legged animals we were talking about.
Yeah.
And this employer was excessively verbally abusive. But the interesting thing was the employees were all women. And the courts looked at that, the court that examined it looked at it and said, normally we don't get involved in these types of cases, but because he is so abusive and because everyone is in this particular protected category, protected class, yes, we're going to find that this violates the law, that is a work environment that crosses the line. Now, interestingly, if he had men and women and was just abusive globally, probably not the same outcome. Probably an outcome where you don't have any protections. And that type of work environment, I get calls often saying, hey, there was a hostile work environment because this person was verbally abusive. And I have to reconfigure that and say, okay, was it toward a protected class? Was it because people were over 40? Was it because of a gender or ethnicity issue, or nationality issue, religious issue? Does it fall within that? And interestingly, usually the answer is no. He's just a jerk, or she's just not a nice person.
Yeah.
That is not a hostile work environment that gives rise to a claim.
By the way, and you know what makes one person comfortable and another? It varies. Like I can tell you, I was actually at the gym recently. This is like crazy. I was at the gym. I wasn't working. No. So I was at the gym, and
good for you.
I grew up in the South, and because I grew up in the South, we say sweetie. And I was walking in the locker area, and I was walking past this woman, and I started to bump her. And instead of us hitting each other, I kind of swung, and I said, oops, sorry, sweetie. And I really made her quite upset by calling her sweetie.
Really?
She actually stopped, let me know, don't call me that, my name is. I didn't mean anything by it.
Yeah.
Just in a balance, because I grew up in the South. It's like sometimes I say yes sir, no sir, in the kindness. So it's a having grace with each other, and sometimes what one person is comfortable with another is not. And that's where you have the lines where what you're describing, some may not think it's a big deal and others may. And what I always think about for workers here, pay attention to the culture you're in. If you don't like the culture, then you're probably not at the right place and go someplace else, right?
And judges will look at that,
Yeah.
and some of them might find something offensive and not other things. And it's tough to know. I encourage employees, communicate those issues first. Okay, if something makes you uncomfortable, like the
Sweetie.
woman at the gym,
Sweetie.
saying sweetie at the gym, if an employee was called sweetie, and I'm having images of the movie Tootsie, if somebody is called certain names and they don't like it, it's okay to be Tootsie and say, I don't like that.
That's right.
Don't say that again. And then, hopefully that resolves the issue. And employee manuals should set up mechanisms for expressing that and for reporting that if necessary. If you take that kind of a position, if something is offensive and you say it's offensive, now if it's a one-time thing, judges aren't going to look at it, juries aren't going to look at it, and judges aren't going to let juries look at it because one-time incidents or minor incidents,
here or there, right?
Yeah, a single inappropriate joke is probably not going to give rise to a claim. Now, if somebody expresses that and it continues on an ongoing basis, then you have your potentially hostile work environment. Then you have a work environment that is uncomfortable, and if it's uncomfortable from a reasonable person standard, EEOC is going to take action on it.
Fantastic.
And the Civil Rights Division will take it.
So I'm gonna delve into one more topic before our show ends today. I always love having you on the show. I just
we always run out of time. We run out of time too quickly.
We run out of time too quickly. Injuries.
Sure.
Injuries in the work environment. What constitutes an injury for a worker, and what rights do we have as workers being in that environment?
Yeah, because of the workers' comp schemes, and I don't mean that in a bad way, because of the workers' comp statutes, if you are hurt on the job, you have a claim for workers' comp, but not a claim against the employer. Now, the exception is if you are intentionally hurt. If some employer strikes you, hits you, pushes you in front of a moving vehicle, whatever it is, then you do have a claim. Okay. But if you have a workers' comp claim, then that is handled through the whole workers' comp mechanism. And that's intended to cover loss of earnings, provided you're out long enough to qualify. It's intended to cover medical bills. And that's why that statutory setup exists. Now, you also can't be fired for asserting a workers' comp claim in retaliation. Just like you can't be fired for having jury duty, you cannot be fired for being a whistleblower of illegal conduct as long as you're reporting it to appropriate authorities, some type of law enforcement mechanism. You cannot be fired for asserting a workers' comp claim. Now, if you are hurt and you're permanently unable to do the job moving forward, then that's a different issue. But if you just file for workers' comp and you have a right to some workers' comp coverage and then you return to work, you can't be terminated for that.
By the way, any employer who has W-2 workers, by definition an employer, they should have workers' comp. You have a right to ask them. That is something that they unequivocally should have, in addition to paying your taxes. Now, I want to ask one delving question on this. Where does, theoretically, for the employer, does negligence come in? Because you could say there's an injury, and yes, there's worker comp, but where does negligence by an employer come into the employee having the right to sue?
Doesn't come into play.
Not at all.
Not at all. They can be ridiculously negligent. Okay. Hopefully they're not, but they can be absurdly negligent, and I could list example after example of what I've seen, but it doesn't cross into actionable conduct unless it was intentional.
Fantastic.
Yeah.
Well, I can't believe this. We're out of time. This is so awesome. So, Justin, you have to come back again.
Okay.
I think I'm going to have to start calling this the Melody and Justin Show because I've thought of several other fantastic conversations for us to have. But I want to encourage everybody out there. Surely this has inspired some questions for you. If you have any questions, please visit us at eye2eyeworkforce.com. Go to Hire Results, share your questions. We'll come back and we'll give you some answers on them too. in this show. So with that, you guys, thank you so much for being here today. Hire Results airs on i2iworkforce.com, Hire Results. And each week it's 3 p.m. Mountain Time, and we air on Facebook. We also have podcasts that you can download and listen in your car. So until then, we're wishing you hire results, and we look forward to seeing you again next week.